About best practice for reducing workplace misconduct through enhanced reporting and resolution. My name is Netta Meidav. I'm the co-founder and CEO of Vault Platform. Vault is a misconduct reporting platform for the workplace, a digital platform that empowers employees to speak up within their organizations. And today we will talk mainly about the EU Whistleblower Directive and other topics relating to ethics and compliance in our day and age. So the EU Whistleblower Directive comes into force in December 2021, which places new requirements on employers when it comes to misconduct reporting by employees. At the same time, there is also a growing trend for employees to call out misconduct. The new law and social movements are both direct result of failings of internal incident reporting and whistleblowing mechanisms to date. During the session, we will look at how these changes bring about really a remarkable opportunity to take meaningful action on matters of culture, ethics, and integrity. By putting in place key processes and making internal reporting channels more accessible, employers can mitigate the risk of ethical breaches or incidents of misconduct hitting the headlines or the courts. We are joined today by two very special guests and panelists, Kate Ash from Neptune Energy, a global oil and gas company, which we're proud to count as one of our clients, and Soren Pedersen from Bird & Bird, a global law firm. Kate, perhaps you would like to start and introduce yourself.
Yeah, sure. So good afternoon, everyone. So as Netta said, my name is Kate Ash, and I'm the head of global ethics and compliance at Neptune Energy. So firstly, maybe to give you a bit of background about Neptune Energy, it's an independent exploration and production company, and we have a regional focus on the North Sea, North Africa, and Asia Pacific. It was set up in 2015 by our chairman, Sam Laidlaw, and then Neptune acquired the NG Group's exploration and production business in 2018. We're geographically diverse and have a gas-weighted portfolio of assets, some of which we operate ourselves and some of which we operate through joint venture partners. And then a bit of background on myself. I'm a lawyer by background, and I worked in the oil and gas industry throughout my career, firstly in private practice, and then for the last 14 years in-house. So I joined the Gaz de France group back in 2007, which then became the NG Group. And as I said, the exploration and production business of NG was then acquired by Neptune Energy in 2018. So at the time of the Neptune Energy acquisition, I moved from a pure legal role into focusing on ethics and compliance. So whilst the business was part of the NG Group, the ethics and compliance was driven by a large corporate team, which oversaw ethics and compliance across the group. However, when our company was acquired by Neptune, which at the time just had 3 staff members, it was like rejoining the company as a startup. I needed to build the ethics and compliance structure into a structure that was suitable for a company of our size, and I needed to build it with limited resources. So it's been an exciting challenge over the last few years, and that's basically me. So I'll pass over to Soren.
Thank you, Kate, and good afternoon, everyone. My name is Soren Pedersen, and I am a partner with Bird & Bird law firm. I myself, I do mainly employment law out of Denmark, actually a relatively easygoing, employer-friendly regulation or jurisdiction. But basically what I think is interesting with Bird & Bird is our international aspect. We are a tech-focused law firm specialized in tech industries, and we therefore have a quite strong practice around IT and tech, and also for this reason within data protection. And the EU Whistleblower Directive that we're going to cover today will actually touch upon both employment law issues, but also data protection issues. So it's quite, from a specialist perspective, quite interesting set of regulation that will come into play here. So I'm looking very much forward to be covering this. So thank you.
Thank you so much to you both, Kate and Soren. For the benefit of our audience, I'd like to spend just a few minutes explaining what Vault is. Kate, Soren, please bear with me. I know you know it all too well. So Vault is an end-to-end digital platform designed for the workplace. And our platform, our app, our employee-facing app enables people to speak up and report incidents of misconduct, be it behavioral misconduct, such as bullying, discrimination, harassment, as well as corporate and financial misconduct, such as fraud, conflict of interest, and accounting issues, as well as breach of EU law, which we will talk about later today, that is covered by the EU Whistleblowing Directive. And our technology leverages behavioral psychology to create this really very much needed psychological safety that enables and empowers people to speak up and report misconduct internally with more confidence. We replace legacy, out-of-date hotline systems by bringing in a digital solution that brings trust into the workplace and connects employees better with their employer and creates a direct communication channel when it comes to the reporting and resolution of misconduct. The app is coupled with a resolution hub, which is effectively a case management system that enables centralization of all the information that is being reported, as well as brings about collaboration between departments that are involved usually in investigating cases internally, such as compliance, legal, and HR, and also creates a direct communication channel with reporters, be it anonymous or not anonymous, as well as providing powerful data and analytics that some of your companies might need for audit purposes, but essentially it provides you with a very good outlook of how the company is doing in terms of its cultural and ethical health. So we're very, very honored to be hosting the session today and have our wonderful guests with us. And we'll dive straight into the questions. But if you have any questions, please do post them in the chat room, as explained in the beginning of the session by Brendan, and we will aim to answer them all by the end of the session. So, Kate, Soren, I'd like us to start with the obvious. This has been an extraordinary year. I think we're all very much looking forward to see the end of it and cling our glasses for a new year, hopefully a better one next year. It put a lot of pressure on companies and employees. Now, for some companies, this will translate into greater incidents of misconduct as employees and employers are seeking to weather the storm and perhaps perform at all costs. What does this mean for companies when it comes to exposing risk in our time? Kate, perhaps you'd like to start.
Well, yeah, I mean, I agree. There are definitely heightened risks, and whether that's through an increased risk of bribery because of the pressure on companies to do deals with financial pressures, and that might in turn lead to kind of bribery or corruption. But also whether it might be something like bullying or harassment. I mean, as we all know, there's been a huge impact on people's mental health in this pandemic. And at a time when companies may be struggling, maybe have made some staff redundant, there may be increased pressure and workloads on the remaining employees to get work completed, which itself could lead to incidents of bullying and harassment. So I think it becomes all the more important as a result of those things for companies to talk to their staff about what they see the heightened risks of being during these times, and also to remind people about the procedures in place for reporting concerns, and to talk to about the different channels that employees can use for reporting concerns.
Thank you, Kate. And Soren, how do you see risk at our times?
Yeah, but I agree with what Kate just said. There's no doubt that in a situation like the one we're in now, there will be enhanced risks of wrongdoing by employees, high-ranking employees, mid-ranking employees, and therefore also a need to facilitate that they basically whistleblow on this. I can give you an example in Denmark, and I think this applies in most European jurisdictions. The government introduced a number of different aid packages that would allow companies to apply for governmental aid during these stressful times. And obviously, when you do this in a COVID-19 scenario, there's a need for a quick assistance, a quick aid, and therefore the control on whether you actually were eligible to receive this was less intense. So actually in Denmark, we quadrupled the penalty for misuse and fraudulent behavior. And we've seen the first court cases on this actually kicking in with a substantial level of penalties. But as with most wrongdoing, the most often the way this is discovered is by someone blowing the whistle, basically. So the more problematic the financial situation is, the more likely bad apples are at misbehaving in one way or the other, financially, or as Kate said, and there will be a need to blow the whistle. And from 2021 December, there will also be a legal framework supporting this when the directive is implemented. So we are definitely seeing something that will rock the boat, in my clear opinion.
And thank you, Søren. And Søren, Kate has mentioned that the importance of reminding people about the different channels by which they can come forward and speak up. Do you believe that there is any limitation of the systems that we've known till date, or what kind of diversification of channels do you think we are requiring?
Well, the directive kind of puts a priority order saying that you should actually report internally as your primarily way of reporting. This is actually stipulated in one of the premises to the directive. But in addition to having a legal obligation to set up such a system, and that can actually be facilitated by a third party, so it is possible to kind of outsource the internal reporting, although it sounds a little contradictory, but it is okay to have this done by a separate provider. If not, then it should be possible to also report externally, and actually the member states will be on an obligation to set up recipients to identify institutions within various areas, and we can cover which areas that are actually covered by the directive in a short while. But there will be an obligation to identify authorities to whom you can report. And then as a third option, it is possible to also do a public reporting under certain circumstances if you have actually tried to report one of the two other ways without this really being taken seriously, or you have a fair reason to assume that one of the first two ways of reporting will not really make any difference. Then you can actually go public, which is actually, I would say, the Wild West way of doing it, but also the way that we have seen earlier instances of where things have blown completely up in the media. So this is the priority: internally, externally, publicly.
And that's really interesting, the way that the European Union has set it up in that kind of cascading way, but definitely encouraging people, first and foremost, to come forward internally and speak up internally within their companies. Now, that's interesting, and I'd like us to kind of dwell on that for a second, because that means that companies must create more trust internally, which is especially challenging at a time that companies have went, working through a completely distributed model, working from home. But companies must create that trust internally in order for people to feel like their, first point of contact should definitely be their own employer. Kate, perhaps, would you like to share any examples of how you went about creating that trust internally and creating an environment where Speak Up is welcomed at Neptune Energy?
Yes, well, we've, in connection with the launch of Volt, because we launched Volt back in October, and since then I've been speaking at leadership team meetings and town halls across our business, so in each of the locations where we operate, explaining why we want to launch the tool, and that's partly because it enables people to report anonymously, which gives them the psychological safety to make a report without our needing to know who they are. I think the problem with anonymous reporting that we've found to date is that you get a report from somebody, but you don't know who it's from, and you can't get any more information from them to find out more in order to investigate it. Whereas through the Volt platform, we can communicate with individuals, we can message them without knowing who they are, but getting all the information we need to then investigate. So I've been talking to our different businesses, encouraging them to use the app if they need to, encouraging them, showing them that it's safe to use, that they shouldn't be worried about retaliation or victimization, and it's building that trust so that if there is an instance that they're concerned about, they don't hesitate to use the tool, because obviously we need to know if there are instances of misconduct going on in the business.
And of course, you've done that with so much messaging about the kind of company you are and your own desire to listen and create an open culture, open and transparent culture within your organization. And I think and I think it's interesting how Soren, back to the directive, which we'll talk about in a second. It's really pushing companies. But we've had that discussion, didn't we, about how it kind of pushes companies into accelerating their efforts on culture and on trust across Europe, which is an incredibly interesting and healthy phenomenon we're seeing all around us. So perhaps, Soren, you'd like to kind of talk us through the directive in more detail. So specifically, maybe it will be beneficial for our audience today to hear about what specific types of wrongdoings are accounted for under the EU directive, but also what can we expect, maybe just from, let's start with the basics. Who is covered by it? When does it come into effect? And what will be covered by in terms of wrongdoing?
Thank you, Nita. Yeah, so first of all, I think one of the key messages at this point of time is that it is a directive. It's not a regulation, it is a directive, and therefore it has to be implemented in the various member states. It's a minimum directive, so it actually allows for the member states to go further into protecting whistleblowers. This means basically that we're not really done with this session. Unfortunately, there's work on tracking how the directive will be implemented. We are at Bird & Bird monitoring this to see how this actually will be implemented in the various member states. We have on our homepage a tracker where you can actually, in a stop sign or traffic signal way, see how far away the different countries are at being compliant. And now COVID-19 has obviously shifted focus away on this by the politicians to other stuff right now, but soon there will be a need to really start the implementation. So in broad terms, what the directive requires the member state to put in place in terms of legislation will be a legislation that protects employees, but also employees of subcontractors, also temp employees, allowing them to report on certain types of wrongdoing. Let me get back to this in a moment. which they have obtained knowledge about from a work-related context. It could be during a pre-contractual negotiation phase regarding employment or during notice, but there has to be a work-related or work relation to the obtaining of knowledge about the wrongdoing. But it's a relatively broad definition, and it will require that whatever reporting channels that are put in place, that they are open, so also these additional individuals are allowed to report, not only your you could say your standard employees. And what the directive then requires of the member states is a protection to report about breaches of, in broad terms, EU legislation. There's an annex to the directive, and it sets out a number of protected areas. It's public procurement rules, financial services rules, for instance, anti-money laundering and stuff like that. It is product safety rules, it's transport safety rules, it is environmental protection rules, radiation, nuclear safety rules, food and safety and animal health and welfare, public health rules, consumer protection rules, GDPR rules, and then also breaches that affect the financial interests of the union and breaches that relate to the internal market, CF the basic EU rules. So what it does not require basically is that member states include non-EU based legislation under the protection. And one of the things that I believe will be very interesting to monitor is whether member states, for instance, will include sexual harassment or misuse of governmental funds that are not EU-based. It could be bribery, for instance, in Denmark. I think we are number 1 or 2 country, being the less likely country to have corruption. But we do have corruption cases in Denmark. We have just had a couple of them actually with significant misuse and bribery. And my guess is that the Danish government will use this opportunity to actually include these areas under the legislation as well. That is possible. It's a minimum directive, as I said. And I would say that at least in Denmark, it would make much sense to basically pool all this into one legislation. But we'll have to wait and see how this will play out.
So as you said, the legislation sets a certain threshold, a certain bar, but that's only a starting point. And it will be interesting to see how different member states are transposing the law and implementing it in a way that covers other areas of speak up and misconduct reporting. I'd like to turn to Kate, because it will be really interesting to see how this legislation is about to drive very big awareness and focus for companies across Europe, looking at refreshing their reporting procedures, as well as tools and others. And I'd like to ask, are there specific considerations or challenges when it comes to ethics and compliance in general? From your standpoint, are there any specific considerations or challenges affecting the energy and oil and gas sector? And what has been your experience in particular with running this globally, given your global remit? Anything you can share?
Well, I guess one of the specific considerations is we have a huge amount of contract staff who work on our offshore platforms. So it's important that we get our message across to them as well as to our onshore staff, so that they're aware of whistleblowing procedures, but not just that. I mean, our full ethics compliance program as well. So I work very closely with our communications team, HR team, all the teams across the business, And part of that is ensuring that there's the correct communication that's given to our offshore teams. Most of them are contract staff, so they're the employees of our suppliers. So we're having obviously to communicate to them, how our expectation that if they do have concerns, that they need to report that to us so that we're aware of them. Other than that, I think I wouldn't say there are any specific other challenges for us as an oil and gas company. I mean, I think we're in the same situation as all other companies, really.
You've mentioned, Kate, the cooperation between different departments, and what I'd love to understand is whether you see that compliance now has a bigger role to play or a seat at the table to drive culture, whilst at the past, perhaps, culture set with HR, whilst conduct set with compliance and ethics. And whether you see that there is now some sort of a shared responsibility for all these matters, and perhaps the lines are becoming blurred between these concepts.
Oh, absolutely. I mean, we do work. We work under what we call the teams of teams approach. So, we work very cross-functionally. I mean, I spend most of my time working with teams outside of legal. So, particularly with HR, with supply chain. We also have a dedicated ESG manager who I do a lot of work with. And we manage that through regular, weekly or bi-weekly calls, quite often just for 30 minutes, but as touch points, so that we can collaborate on the various issues, such as building a culture of integrity within our business. I mean, to give an example, at the moment we're working on equality, diversity, and inclusion. We have a team from communications, HR, legal, ethics, compliance, all sitting on the team. We've carried out a survey across the business to understand what our employees think of how we're doing. And we've also held focus groups in each of our locations where people can talk confidentially about how they think we're doing from those points, from equality, diversity, and inclusion point. And that's getting people to be able to speak up, to feel safe in voicing any concerns they've had, and then to develop those into an action plan, which we'll work on over the next 3 years to continue to improve in these areas. I think it's really important because it's through making the company a better place to work that people want to work in, that people are proud of working in. It will just build this culture of integrity and as you've mentioned before, build this trust.
Thank you. That's super insightful. Søren, from your view, let's put the directive aside for a second, but just, with your employment hat on, do you see this connection between creating a better culture internally, creating this trust, and seeing the impact on that in terms of, say, reduction of legal challenge that employees are bringing against their employers? Do you see that obvious link? Do you see companies are performing better by taking action, just like Kate just mentioned? Søren, I believe you're still muted.
Yeah, sorry, I just I had just a technical glitch. So if I heard your question, yeah, there's a relation between building, I think, a culture within the organization where trust is a priority, and thereby avoiding obviously different types of disputes with both obviously individual employees, but also labor unions. So building a culture, I think, is very, very important, and very good way to limit the number of disputes as seen from the employer side of the table. So it's very, very important. And I think this directive, I'm not going to go down the details again, but I think this is an opportunity to actually mapping whether you are the right place in this relation. I hope this answers the question. I had
yes, definitely. So would you assume that that this will now bring a wave of a lot of let's call it self-awareness of companies across Europe to the kind of to how trusted are they by their people, and whether they have indeed the right channels and avenues in place for speak up?
No doubt about it. I mean, there will be a legislation in place that will require employers to make sure that the channels are there, and I think that it's not only done, by, for instance, outsourcing it. You have to dedicate a team that will be in the receiving end of a reporting. So you have to, plan for this basically, and I might be naive, I don't know, but I actually think that going through that process will actually most likely put a focus on these issues, and therefore also bring around a better work environment in European companies. I truly believe that.
I think it's hopeful, not naive, and we're very much, we're very much excited to be to help companies charging that process, which is a very, it's a very healthy process to go through. So, I think that's a great note to kind of conclude our panel here, as I'd love to take some questions from the audience. Before I do, let me just mention that Vault Platform has partnered with Bird & Bird to produce a white paper discussing all the elements of the upcoming EU Whistleblower Directive. I just want to again highlight and mention that the directive is coming into force and will be effective for every employer with more than 250 employees on EU soil as of December 21. 2 years later, down the line, from December 2023, the directive will impact every employer with 50 people or more. Our paper discusses these issues, and it also talks about how Vault helps to meet the requirements of the directive, and on top of that, beyond compliance, help to build the right culture of trust within organizations. If you're interested, the paper will become available in a few weeks. And if you're interested, I'd love to share a link in the chat. You can register your interest, and we will send the paper to you as it and when it becomes available. So I'll just do that right here in our chat. Just a second. And I am very happy to accept questions from everyone. So here's the link if you'd like to register your interest for the paper. So starting with a question here about certain types of wrongdoings, and can you give examples of these types of wrongdoings? Again, they are covered by the paper, so you're very, very welcome to, so the person who asked us this question, very welcome to register your interest and read all about it. But perhaps, Søren, perhaps you would like to give us, two specific examples of wrongdoings that are covered by the different categories of breach of EU law.
Yeah, so for instance, a clear example will be unlawful establishment of, if you have, for instance, you establish, I will start with another example. Right now, we actually have a scandal in Denmark where it turns out that a manufacturer of concrete for building purposes, they have, mixed litter into the concrete, and now we have a high-rise building that is built more or less on with a foundation made of concrete that is mixed with litter. That is a product safety issue that I think will undoubtedly be covered by wrongdoing protected by the directive, because it relates to product safety. You might recall some years ago in China, there was also poisonous substances put into infant formula. That's also a clear example that would be covered by the directive as an example of wrongdoing. And you could also have, if you divide the market between companies in breach of EU competition legislation, then this is something that if you create an unlawful cartel, for instance, that will undoubtedly be covered by the directive also. So.
Thank you for these two examples. A second question is about Vault platform and whether it's a cloud-based solution. Yes, indeed, Vault is a cloud-based SaaS platform. There's a question here about demo. We would absolutely love to arrange a demo. You can approach us directly through the Compass app. We can also follow up with you, and there's a book a demo option on our website, vaultplatform.com. I'll post it here again, and we would love to demo it for you. So thank you for your question. Any additional questions? Brendan, am I missing on something here? Do we have any additional questions?
That's it that I saw in the chat for now.
Okay, well, fantastic. So thank you all very much for joining us today. I can already see announcements here by the ACC about the very exciting closing session that awaits. Thank you very much all for joining us. And it was a real pleasure to have this discussion with you today, Soren and Kate, and hear these kind of different perspective, a legal one and one coming straight from the field, and hear about the different elements and considerations with implementing reporting systems in-house and enhancing ethics and compliance within your company and within your clients, Soren. So thank you so much for joining us, and have a great day, everyone.